So you've closed on the client, you've sent over your contract to sign, it comes back to you marked up like it was your third grade teacher. What do you do? What are your options? Today on the podcast. Stick around.
This is the Wedding Industry Law Podcast, a podcast dedicated to wedding professionals that are just trying to keep it legal. And now, your host, Rob Shane.
Hey out there, welcome back to the show. This week, we're going to be talking about what are the implications of a client marking up or refusing various terms of your contract. So this is not something that's uncommon. And if you want a little bit more in-depth explanation of the stuff that we're going to be getting into, I would highly recommend that you check out episode 23, which deals with the concepts of offer and acceptance. So I would highly recommend you check that episode out. It's kind of like the compendium to this episode. But anyway, so you've got the client's email or text or whatever the case may be, and you're looking at your contract and it's been marked through, it's redlined. What is that essentially? That is most of the time going to be what's called a counteroffer. Your contract is acting as the offer to the client. The client has said, I'm rejecting that offer, but I'm not rejecting you. I'm redlining things or changing things, and now I'm becoming the offeror for you to accept the changes. That's more than likely, from a legal standpoint, what's happening. So what do you do? What are your options? Your options are to accept their offer, in other words, accept those changes, or make what's called a counteroffer. In other words, don't accept their changes and then give them back something. Say that I'm rejecting your changes, but I'm not rejecting you. Here's my new offer to you. And most of the time, that's how it's working out. You are going to say, whoa, wait, I'm not going to accept that, or I'm going to accept this. And then you give them a clean sheet of paper or a clean email or whatever the case is. And then that's what goes back to the client. They sign it, and then you're hitting the ground running. So from a legal standpoint, that's what it is. Offer, acceptance, contract formation. Again, go to episode 23 if you want to learn more about that. But with regard to Rob, well, how do I know whether or not to accept those changes? How do I know whether or not, I should run away from this client? From a certain standpoint, I kind of advise clients to do kind of like a 3-point test. The first test is understand what are the business ramifications of the change that the client is wanting to make. In other words, is the change something that addresses the business of the contract? So for example, perhaps you're a planner and your contract dictates, well, the client can contact me between 9 a.m. and 5 p.m. and I will give you a response back within an hour or within a business day. And communication policy, and the client strikes through that. And the client says, I want to talk to you whenever I want to, okay? That's something that's striking at really the heart of the business, not necessarily a legal ramification. So is that something that is negotiable to you? Are you willing to concede that? Okay, if you are, then go ahead and accept. But that's the first layer of analysis of how is this going to affect my business, how I'm relating to this client. Okay. The next kind of test that you should put the change through is what are the legal ramifications, to the extent that you can make heads or tails of that. I know that some of the terms, well, Rob, I really don't understand really why that's in there, but know that it needs to be in there to the extent that you can figure this out. So for example, if the client is striking through like the non-refundability of the payments clause or the striking through the indemnity clause, okay, these have direct legal ramifications on you. So that's the second test. Like, what are the legal ramifications? If that is too much, if that's too hot to handle, then do not accept that change. Okay. And there are going to be some legal things that are blatantly obvious to you and some things that might not be. So again, you might want to talk to a lawyer if somebody's really redlining the crap out of your contract, but it definitely, if they're striking through the money stuff, that's direct ramifications to you. And you might want to reconsider whether or not, to have this person as a client. So running it through kind of a business analysis, is this going to mess up my operations? Running it through a legal analysis, hey, am I more likely going to be sued if, this stuff gets taken out? And then finally, and this is kind of, for at least for me in my experience, even before I was a lawyer and I was a business owner, is the gut check. If you get this contract back and it's redlined, it's hard not to take that personally, but don't take it personally. It's just somebody trying to do business with you. But there is a sort of, level of like, if this person is so non-trusting of me, if this person is, wanting to go fine-tooth comb through these type of things and make me capitulate to certain terms, is this somebody that I really want to work with? Is this somebody that I want to spend the next year of my life working with? And so I guess what I'm saying is that the third test is the gut test, the gut check test. How does it make you feel based on what they have marked up? Sometimes it hits you in the gut. It's like, man, these guys are weirdos. I'm not dealing with this. And it functions as a check at the very start of the relationship. So if you can run that analysis and then of the business, legal, and then the gut test, that can, really clear up whether or not you're going to clean it up and send it back to them, with your own changes or accepting their changes. So that's kind of the give or take. Now, I'm not trying to give you business advice. I'm really not trying to give you legal advice. I'm just trying to give you legal education. Wink, wink. So there are, business decisions that, it's going to be left to you. Like you're in the driver's seat with regard to that. There's not really a recommendation I can make you in terms of business decisions. But that being said, just understand what your non-negotiables are. So if it's business wise, like, no, there's no way I'm not going to require my client to have liability insurance. If it's a non-negotiable legal wise, no, there's no way that I'm going to allow my client to be able to change the date, for example. That's your non-negotiable. Or if it's a gut check, okay, yes. If they've marked up more than 5 things, that's a gut check, they're gone. Okay, so understand what your non-negotiables are, and that's really going to help you, figure out whether to keep the client or send them a counteroffer. Okay, so now that you've decided, okay, these are acceptable changes, or not necessarily acceptable, but I will integrate them into some new wording and see if they'll take that. If you're at that phase where you're going to hand them back something, I think the biggest recommendation for you at that point is going to be to make sure that the language is clean on the contract. In other words, don't simply rely on the text exchange or the email exchange to bring clarity to your contract. Make sure that the contract itself is the end-all be-all with regard to any changes that the client has made or maybe that you have amended yourself, if that makes any sense. So in other words, don't have your original contract with the strike-throughs in it, or your original contract with the strike-throughs in it and then an email back and forth exchange. Clean all that up into a final version of that contract that the client then signs. So how this plays out is it's recommended that you take whatever amendments that they want, you take away the scratches and actually input new information into the contract, give it to them, and then they sign it. Okay. Make sure that whatever the final understanding is reduced to the contract and not left to any superfluous or extraneous documents or emails or text. Everything should be in the contract. That's the safest play for you once you've decided, yes, I'm going to keep this potential client as a client with their changes, but we're going to change the contract, blah, blah, blah. That's the best course of action for you. So in other words, what to do when a client marks up your contract? Run through that 3-part test of how this is going to affect my business if I accept them. If it's something that you can accept, okay, that's fine. work it into the language of your contract and give it back to them. If it's not something that you want to do, but you still want to try to work with them, come up with proposed language, put that into the contract, and then give that back to them and see if they sign it, or run away. Those are typically going to be your three options, but that's the test that you run through it, and that's the best practices for how to address it. And I think this might be a record time for an episode of this podcast. So let me know what you think. Do you like the shorter episodes or do you like the longer episodes? Let me know in the comments below. Please be sure to like and subscribe wherever you get your podcast from. New episodes of the Wedding Industry Law podcast / show. I don't know what I'm calling this yet. It's 2021. I still haven't figured this out. It's a work in progress. But new episodes every Monday, wherever you get your podcast from, and on YouTube. And with that, folks, we'll see you next week.
Thank you for listening to the Wedding Industry Law Podcast. This podcast is intended for general information only. Nothing in this podcast is intended to be legal advice. Do not rely on this podcast for your legal matter. Instead, consult an attorney in your area. Thanks, obrigada, até semana que vem.